peoples of the proper authorities and seek judicial remedies in accordance with the Constitution and applicable laws and rules. Mr. President, I respectfully oppose this resolution on the ground that the moment Senator De La Rosa surrenders, he will be immediately brought outside Philippine territory and deprived of the protection and remedies of Philippine laws and courts. To surrender Senator De La Rosa is to effectively surrender Philippine sovereignty itself. The International Criminal Court Pre-Trial Chamber 1, Mr. President, has confirmed that it issued a warrant of arrest against Senator De La Rosa on November 6, 2025. It unsealed the warrant only on May 11, 2026. The warrant orders the arrest and surrender of Senator De La Rosa under Article 102 of the Rome Statute. To surrender Senator De La Rosa is to deliver him to the custody of the ICC in the Netherlands, a foreign jurisdiction where Philippine laws have no force and Philippine courts can do nothing. While the sponsors pretend that they want Senator De La Rosa surrendered to authorities in the Philippines, in reality, they want him handcuffed, dragged to the airport, dumped on a plane, and banished to the clutches of the ICC in the Netherlands. While the sponsors claim they want Senator De La Rosa to avail of Philippine judicial remedies, in reality, they want him removed from territorial jurisdiction of the Philippine courts and therefore deprived of the rights and remedies that every Filipino enjoy under our laws and constitutional protection of due process. In fact, Mr. President, if the sponsors will have their way, the Senator De La Rosa is transported to the Netherlands. The constitutional issues now pending before the Philippine Supreme Court will become moot and academic. The Philippine Supreme Court will be ousted of jurisdiction and prevented from fulfilling its constitutional mandate. There will be no end to this constitutional crisis, for in the years to come, the ICC, with much delight, will pick us up one by one, Mr. President. Only the Supreme Court, Mr. President, can stop this nonsense. The sponsors of Senate Resolution number 395 cited the service of warrants of arrest on the late former Senator Juan Ponce Enrile, former Senators Laila de Lima, and former Senator Antonio Trillanes. But please take note, Mr. President, they did not mention that their co-sponsor, Panfilo Lacson, evaded service of arrest warrant. The sponsors acknowledged that the late former Senator Enrile, former Senator de Lima, and former Senator Trillanes were all subjected to arrest warrants issued by local courts. For the record, Mr. President, all of them have exercised their rights under Philippine laws and availed of Philippine judicial remedies. Yet the sponsors are blind to the peculiar situation of Senator De La Rosa. Unlike the late Senator Enrile et al., who faced arrest warrants issued by Philippine courts, Senator De La Rosa is facing an arrest warrant issued by the ICC, a foreign court which jurisdiction the Philippines does not recognize anymore. Moreover, unlike the former Senator Enrile et al., who availed of the rights and remedies of Philippine laws and courts, Senator De La Rosa will be deprived of all this, as he will be banished to foreign land on the other side of the planet, beyond the reach of Philippine laws, and forever detached from his family and constituents. Therefore, if the sponsors are sincere in their desire that Senator De La Rosa be accorded the same rights and remedies as those enjoyed by Senator Enrile et al., they should not allow his surrender to the ICC. They should instead withdraw Resolution number 395. The sponsors recognize that under Republic Act 9851, it is the regional trial court that has exclusive original jurisdiction over offenses constituting crimes against humanity. This statement of the sponsors reinforces the position of the majority that the ICC warrant of arrest should not be implemented against Senator De La Rosa, and he must remain under the Senate custodial protection under the ICC arrest until the ICC arrest is quashed by Philippine court. First, Section 18 of RA 9851 provides that it is the Philippine Regional Trial Court that has exclusive original jurisdiction over crimes against humanity. Section 17 allows the transfer of jurisdiction to a foreign court only by way of extradition and provided the Philippine court is unable to try and decide the case. Therefore, RA 9851 itself bars the ICC from taking jurisdiction. The acts attributed to Senator De La Rosa. Kagaya po ng nasabi ko na kahapon, Mr. President, wala po tayong extradition treaty sa ICC. At wala na po tayong membership sa Rome Statute sapagkat nag-withdraw na po tayo. Sa makatid, wala na pong treaty. Yun po ay nakasaad sa Article 17 ng 9851. Second, at the United Nations, the Philippine government, through the permanent representative, pronounced that the state policy under RA 9851, Philippine courts have the exclusive jurisdiction over crimes against humanity. It also declared that Philippine courts have the competence and capacity to try and decide these cases. Kung ganun po pala, this is the national policy already articulated even before the halls of the United Nations. Bakit pinipilit pa natin na i-serve ang isang warrant of arrest na hindi na natin kinikilala ang jurisdiction ng lintik na ICC na yan? Hence, the Philippine state policy is to assert and exercise local jurisdiction rather than recognize foreign jurisdiction such as that of the ICC. Third, the Philippine government has assumed and exercised local jurisdiction under RA 9851 over the crimes arising from extrajudicial killings allegedly committed by Senator De La Rosa. Philippine local jurisdiction already set in when Senator De La Rosa was served a subpoena by the CIDG in connection with its investigation of said extrajudicial killings. Senator De La Rosa has stated that he is ready to respond to the subpoena. It is of no moment, Mr. President, that today the CIDG withdrew the subpoena. It is a legal ruse. It's a legal ledger domain. Ang akala nila kung withdraw nila yung subpoena, wini-withdraw na yung case. No, Mr. President, the case is kicking and alive. It triggered already the jurisdiction of our National Prosecution Service and eventually the courts of this country. The crimes under investigation by the CIDG are the same crimes for which the ICC has issued a warrant, Mr. President. Under the principle of complementarity, said ICC arrest warrant can no longer be enforced because there is now a genuine domestic investigation and prosecution currently taking place in this country. The assumption of jurisdiction by Philippines over the acts attributed to Senator De La Rosa and the person of Senator De La Rosa automatically and absolutely bar the ICC from exercising jurisdiction over the same acts and on his person. These circumstances, and by reason of the principle of complementarity and the Rome Statute, strip the ICC, Mr. President, of its jurisdiction. Therefore, given that the sponsors themselves admit that under Republic Act number 9851, Philippine courts have exclusive original jurisdiction over the crimes for which the ICC has issued an arrest warrant against Senator De La Rosa, given that the Philippines have assumed jurisdiction over said crimes when it served the subpoena on Senator De La Rosa, and given that Senator De La Rosa will respond to the subpoena, said sponsors cannot but agree that the ICC warrant of arrest should not be enforced on the good senator. It should be borne in mind, Mr. President, that the protective custody granted to Senator De La Rosa is for the sole purpose of ensuring the following. First, that only Philippine warrant of arrest, not an ICC warrant of arrest, will be enforced against him. Second, upon service of Philippine arrest warrant, he shall enjoy all the rights and privileges granted by the Constitution and the laws of the Philippines. Third, that he can avail of all Philippine administrative and judicial remedies and processes. Fourth, he shall remain in Philippine territory where he can exhaust all said administrative and judicial remedies and processes. And finally, and most important of all, the jurisdiction that the Philippines has assumed over his alleged crimes under R 9851 must be exercised to the total exclusion of the ICC. Finally, Mr. President, the sponsors of Senate Resolution number 395 question the constitutional and statutory basis of the resolution granting De La Rosa Senator De La Rosa the protective custody of the Senate. These purposes, Mr. President, are legitimate. They do not contravene any Philippine law. In fact, they ensure that the Philippine laws are respected and enforced in Philippine territory to the exclusion of the Rome Statute that the Philippines no longer recognize by reason of its withdrawal therefrom. The protective custody granted to Senator De La Rosa addresses not only an extraordinary threat to his liberty, but also an existential threat to the integrity of the Philippine Senate, and by extension, a grave peril to the independence of the Republic itself from foreign interference. It is a threat emanating from a source that the Philippine Constitution laws did not anticipate. A foreign entity, Mr. President, the ICC, which jurisdiction is not only questionable but also lost due to the Philippines' withdrawal from the Rome Statute. The protective custody addresses a threat whose profound ramifications include regime change and outright interference in the sovereign affairs of the Philippines. To give inroads to the ICC is to enable it to structurally alter the Philippine Senate and disenfranchise Filipino voters for the arrested senator will be rendered futile. Whose votes for the arrested senator will be rendered futile and meaningless. The ICC will transform Philippine agencies as its own puppet and tools and hold hostage Philippine officials, civilian and military, against whom it can initiate prosecution anytime and in perpetuity. The Senate's custodial protection is born out of self-preservation, which is the first law of nature for both men and institution, Mr. President. The Philippine Senate has granted custodial protection to witnesses in order to ensure the continuity and integrity of its legislative hearings. It is with more reason that it can and should grant custodial protection to its members to enable them to discharge their mandate unmolested by a foreign entity like the ICC and its local tentacles and subalterns. The Philippine Senate and its members enjoy privileges and immunities under the Constitution and laws so that they may discharge their functions effectively, efficiently. Specific privileges and immunities were designed to address the usual disruption to these functions. However, they did not anticipate disruptions from a foreign source. Thus, a purposive interpretation of the Constitution and laws is necessary in order for the Philippine Senate to meet new forms and sources of challenges. For this reason, Mr. President, it adopted Resolution Number 44 and implemented the same with respect to Senator De La Rosa. The Philippine Supreme Court did not also see it coming. It has to do its job and rise to the occasion, Mr. President. In the end, the dignity and integrity of the person of Senator De La Rosa, as well as of any member of the Senate, including the sponsors, represent the dignity and integrity of the institution of the Philippine Senate vis-a-vis foreign interference. Resolution number 395 will weaken its dignity and in the process, destroy its integrity as an institution that stands as the last bastion of democracy. Dapat lamang na ibasura ang resolution number 395.